Welcome back to This Week in Immigration. I'm Rachel Iacono. On this week's program, This Week regular Theresa Cardinal Brown, Director of Immigration and Cross-Border Policy here at BPC, will host a timely conversation on the 2020 election results and its implications for comprehensive immigration reform with special guest Charles Kamasaki. And later, a supersized edition of the Gavel, where we'll cover recent rulings, rules, and regulations on everything from DACA to the H-1B program and to the public charge rule. Stick around. First up, with President-elect Joe Biden set to take office on January 20th, there has been a lot of discussion amongst immigration advocates about what is legislatively feasible in terms of reform under the new administration. To help us walk through these possibilities is special guest Charles Kamasaki, author of Immigration Reform, The Corpse That Will Not Die, an insider's history of the Immigration Reform and Control Act of 1986. Theresa, I'll hand it over to you to introduce Charles to the show.
Thanks, Rachel. We are so happy to have Charles Kamasaki joining us. Charles Kamasaki is Senior Cabinet Advisor at Unidos US, formerly known as the National Council of La Raza, and is a senior member of their management team. He's previously the Executive Vice President of NCLR and has for 2 decades managed that group's research, policy analysis, and advocacy. He has been part of probably, I don't know about how many count you have, Charles, 5 or 6 attempts at comprehensive immigration reform, one of which was finally successful, and that was the major topic of your book, the Immigration Reform and Control Act, The Corpse That Will Not Die. So welcome to This Week in Immigration, Charles.
I'm thrilled to be here, Theresa. I'm such a big fan of the show.
Thank you very much. So as I mentioned, you've been involved in many attempts at comprehensive immigration reform, and I want to ask about the title of your book, The Corpse That Will Not Die. We are now hearing that President-elect Biden intends to introduce comprehensive immigration reform legislation on day one of his administration. But others, including many immigration advocates, are kind of skeptical and saying the idea of CIR is dead. So from your history with IRCA and other efforts, why do you say that comprehensive immigration reform is the corpse that will not die?
Well, to be honest with you, I actually ripped off the title from an article that a guy named Larry Fuchs, who was the executive director of the Select Commission for Immigration and Refugee Policy, which was the commission that produced what later became IRCA, wrote an article years later that referred to IRCA as the corpse that would not die, and I adapted it to also apply to future reform efforts. And I think it's notable just in the sense that at various points in time, pretty much every immigration reform in recent history has been declared a corpse. In some cases, it's been declared dead on arrival, even upon introduction. And I think that gives you a sense of how difficult it actually is to produce immigration reform legislation.
Yeah. So let's talk about some of those efforts. Your book focuses a lot on the one reform that we know did succeed, and that's the Immigration Reform and Control Act. But, we see that now in looking back at it as happening in 1986 and maybe happening all at once, but you know better, right? That was a long process to get there. You want to talk to us a little bit about the history there?
Indeed. I mean, if you look at the roots of IRCA, it actually began in the early 1970s when then Peter Rodino, a congressman who was the chair of the immigration subcommittee, was first trying to pass immigration reform legislation, and ultimately, as you know, didn't come into fruition until 1986. And I would note that the 1990 Act, which followed 4 years later, was in many ways, I believe, part and parcel of the IRCA debate. And so I really treat those two bills together as comprehensive reforms.
Yeah, so 86 was the legalization and enforcement piece, and 90 was the reforms to the legal immigration system that came a little later. Yeah. So, obviously following that, there's been several other attempts at comprehensive immigration reform. What are some of the common threads that you've seen between the successful efforts of IRCA and IMAC 90 and the less successful efforts, shall we say, in the 2000s up through 2013, 2014?
Well, as you know, being the expert that you are, the templates for these bills look quite similar, often because the issues are intertwined. IRCA and really a couple of its predecessors included provisions to affect legal immigration, temporary workers, unauthorized migration, in part because there are real trade-offs among all of them. It's also Doris Meissner, my colleague at the Migration Policy Institute, likes to talk about immigration as a good government issue, that regardless of the politics, regardless of the personalities, reality often drives one towards these same sets of issues, even though, the details often differ.
So you've mentioned sort of one of the policy reasons why we tend to gravitate toward the big comprehensive bills, but what are some of the political reasons why that continues to be a strategy that comes back again?
Well, there are lots of political reasons, and I think they actually often change a bit over time. But to maybe oversimplify, supporters who lean towards restrictionism will always want to talk first, and they'll want to lead with enforcement, in effect as the balancing in order to justify what was in IRCA a fairly modest legalization program, as well as a very large and expansive agricultural worker legalization program. And on the other side of the coin, right, advocates who lean towards more generous immigration will often want to lead with the more generous provisions of the legislation, and will look at enforcement and restriction as sort of the balancing elements that you have to swallow in order to get the good stuff. But there are also procedural reasons, and maybe this starts to get into what might be happening early next year. It's a truism on Capitol Hill that that when you have a moving train, everybody wants to jump on. The other analogy that's often used is a Christmas tree, where you have a basic bill and everybody will want to add their ornament onto the bill. So let's say, for example, as some are arguing, that President Biden might lead a legislative effort. That's not to say he won't also introduce a broader comprehensive reform, but I think most people recognize that's more likely to be a messaging bill. But let's say they lead with an attempt to pass the DREAM Act, right? You could make an argument it's the simplest, it's the most sympathetic population. Pretty quickly, if that starts to move, people are going to ask, well, what about TPS? Then the growers and farm worker advocates are going to say, well, what about the Farm Labor Modernization Act? That passed the House last year. It should be added this time. Then folks are going to talk about H-1B reforms and what are required there. And pretty soon people will be saying, well, what about H-2B reforms?
Right.
And, something that starts as quote unquote piecemeal or pretty modest or narrow could quite easily become much broader and pretty soon starts to look comprehensive, right? Because the minute these other additions are added on, you'll hear from restrictionists who will say, whoa, wait a minute, if we're going to talk about not one, but two, maybe three legalization amnesty programs, we're going to need a heavy dose of enforcement.
Yeah. And I think if you look at just like the attempts in the Obama administration, even the Trump administration, you can see versions of that, right? So in 2013, you had the Gang of Eight that worked and negotiated a comprehensive bill to try to get everybody who wanted something in it, right, on board at the front. They were successful in getting that past the Senate, even though they needed to add some floor stuff to get the extra votes. And then it died in the House because it didn't have momentum there. During the Trump administration, you saw efforts at trying to get DACA, a DREAM Act, and bipartisan advocates had put forward legislation. They wanted to try to keep that narrow. And pretty soon you had the White House come in and said, oh, but we want these changes to asylum law as well, right? So everybody has an incentive to like throw it on, right?
And in fact, if you recall, Theresa, the original proposal there was Dream for the Wall.
Right.
And even I would say many pro-immigrant advocates couldn't stop there, even though some of those, quite honestly, were those who were for many years arguing for a narrow Dream Act. And pretty soon they started adding provisions that looked a lot like DAPA, right? So fairly soon you had something that began to look pretty comprehensive.
Well, the ending story of all of these is they didn't pass. So what do you think was the difference with IRCA and IMAC 90 to these subsequent efforts?
I never think there's one cookie cutter answer. The fact of the matter is, in the last 50 years, there's been one comprehensive reform. There was an attempt at comprehensive reform, if you remember, in 1996 that later became IRA, but that ended up being an enforcement-only bill.
Right.
And there had been, smaller bills, the Refugee Act, again, kind of different in character. So I think it's important for advocates and pundits and observers, scholars, to just start with the proposition that these things are really hard. And yes, they may be getting harder all the time, but in a note of optimism, I guess I would say IRCA was declared dead on 3 occasions before it was revived. The 1990 Act literally died twice before it was resurrected. So these are always close-run things, past failure is not a reason to stop; it's a reason to keep trying.
Is there something to be said for the fact that we've had so many attempts? I mean, if you count at least 3 attempts under the George W. Bush administration, you have the DREAM Act and 744 during the Obama administration, you have the DACA bills that were tried to do under the Trump administration. If Biden comes in with a new bill now, we're talking, essentially 6, maybe 7 different bills in the last decade and a half. Is there something to say for keep trying till you get it right?
I think there is. And in fact, that was very much the flavor of the IRCA debate. So when IRCA was first introduced, it was introduced on a record of more than a decade of failure. A bipartisan team of Senator Simpson and Congressman Mazzoli, Simpson being a conservative Republican, or at least we thought of him as conservative back then. He's probably a moderate in today's GOP. And centrist Democrat Romano Mazzoli and Peter Rodino, I think by all accounts a liberal Democrat, got together to try and move a bill. And their introductory statements were all about the fact that Congress had failed to wrestle with this issue since Peter Rodino's first employer sanctions bill in the 1970s. And in fact, that issue itself goes back to the 1950s, to the Walter McCarran Act, when there was an attempt to make it unlawful to knowingly hire an undocumented worker. So, yes, one can look at the past 15 years or so and see a record of failure. And you can, those of us who might be looking at it with a glass half full eye might say, geez, it looks a lot like the 15 years that preceded IRCA.
So looking ahead to what we can expect in a Biden administration, we know that Congress is going to be very closely divided. We don't quite yet know who's going to have that tipping point in the Senate. What do you think are going to be the key factors in whether or not this time could be the time? I mean, obviously you have an administration in the White House that is going to push for it, which is, I think, always necessary, but is also distracted by a couple of things like, I don't know, COVID and economic recovery that are going to take a lot of time, right? And where are the champions in the House and the Senate that you think might come up? Throw me a little bone of prognostication, if you will.
Yeah, I'm happy to prognosticate, Teresa. I wish my predictions were more accurate than they are. Let me start with the big picture, and then maybe we can get a little bit more specific. Um, if one were to look at just 2006 and slash 2007 and 2013, 2014, the outlines of those bills look a lot like each other, right? They look very similar at the top level: enforcement, legalization, legal immigration, temporary workers. But there were huge differences between what the Senate passed in 2006 and what it almost but failed to pass in 2007. And that had to do with one person. It had to do with the fact that John McCain, who was the co-sponsor of the Senate effort in 2006, decided he was going to run for president, and he bowed out in 2007, and left in his place was this team of John Kyle and John Cornyn. And even as I thought the substance and the narrative of the debate was moving left, they moved right. And combined with the fact that President Bush, who was, I think, a strong supporter, by 2006, he was presiding over a terribly unpopular war in Iraq. He had failed in his major domestic initiative, which was to privatize Social Security. So the fact of the matter is he didn't have a lot of stroke left, and reflexively started to move towards his base in order to try and pass a bill. And that was actually exactly the formula that failed. So I think looking forward, the tendency on all sides, given how partisan debates are these days, is going to be to kind of start with the base, and then try and pick off some supporters on the other side. I actually think that's a mistake. I think there is quite a broad consensus around what can and should be done. And I might take a page from the bipartisan group that's, might be trying to get a CARES Act follow-up through now, where I think if as the last year has shown, despite the incredibly widely recognized need by experts and people on the ground to do something to respond to the pandemic, right? Politics has led us nowhere. And yet a bipartisan group has, I think, a better than 50-50 chance of leading this lame duck Congress to enact some sort of response. And I would take a page from there, and I would encourage President Biden and Ali Mayorkas and whoever's going to lead this effort in the Biden administration, as well as the Congress, to, maybe try and start bipartisan rather than start with the base and then think that somehow we're going to roll the other side or trick the other side into choosing something that or accepting something that we know they're not going to want.
Well, you're singing the song of the Bipartisan Policy Center right now, which is, we always believe that you can probably have an easier time working out from the center than working from either of the bases across the middle. Charles, thank you so much for joining us on This Week in Immigration. Once again, his book is Immigration Reform: The Corpse That Will Not Die. It is available, I assume, at all major booksellers, online and in person, correct?
It is indeed. And for people who want to know a little bit more, just to do a little bit commercial, you can check out the book website. It's at www.charleskamasaki.com.
Thank you very much for joining us, Charles. We appreciate it.
Thank you, Theresa. It was a thrill to be here.
To wrap up our show today, a supersized edition of the Gavel with Theresa Cardinal Brown and our immigration fellow, Sadiqa Nepal. There's been a lot of movement in the immigration space over the last few weeks as the Trump administration hopes to finalize several rules and regulations before leaving the White House in January. So let's start with the DHS and DOL interim final rules that were put forth in October regarding the H-1B non-immigrant visa program. On December 1st, the U.S. District Court for the Northern District of California blocked both those rules from being enforced or implemented on the grounds that the agencies did not have just cause to promulgate the rules without notice and comment. So Sadiksha, I'm going to turn to you to kind of explain what's going on here. Can you give us a summary of what both these rules sought to do to the H-1B program and explain the grounds on which they were blocked?
So I'm going to begin with a little background about what the rules were. So the DHS and the DOL both came up with the interim final rule in October. The DHS rule was supposed to go into effect on December 7th, but the DOL rule actually went into effect immediately. And they had to do with the H-1B eligibility, or what we define as H-1B, and how prevailing wages are computed. So the DHS rule, as I mentioned, is related to the definition of what an H-1B is and who qualifies for it. So they were trying to revise what the specialty occupation means. And they were also trying to shorten the length of the visa for some of the contract workers. The Labor Department rule had to do with wage protection for permanent labor certification, but as also for labor condition applications. This would incorporate changes to the prevailing wage. It would make minimum salary for entry-level positions really high. It would probably prevent a lot of international graduates from entering the market. I was actually doing some search, and the Wall Street Journal mentioned that the entry-level position for an electrical engineer in California would be the salary would raise up to $127,000 versus $88,000 prevailing wage, which is needed now. So in effect, both these rules would make it much harder to employ foreign workers. It would narrow the definition of specialty occupation, then as well as kind of take the floor of what is entry-level position wage much higher. Kevin Cuccinelli, actually, who is the deputy secretary for the DHS, mentioned that under the new provision, 1/3 of the applications could actually be rejected. So now, why did they get blocked? The Trump administration actually rushed this interim final rule, citing good cause exception, and they mentioned that the rising unemployment rates due to COVID-19 is a reason to get this through very fast. But the court doesn't see that way. And they cited that this is not a good enough basis to not allow a customary public comment period on these IFRs, and it actually violates the Administrative Procedure Act, which comes up again. So that's the reason why they don't pass. If you don't allow enough time for the public to comment on a rule that's going to become a law or a policy change, the courts usually don't like that.
So Theresa, with both of these rules currently vacated by a U.S. District Court, what next steps, if any at all, could the Trump administration take to get either of these rules finalized before they leave the White House in January?
Well, the long way round would be to reintroduce them and as a proposed rule and allow for notice and comment. But that would most likely mean that they would not have time to finalize them before they left office in January. The history of this administration is to appeal every ruling that goes against them. So I am absolutely sure they will try to appeal this one to the Ninth Circuit Court of Appeals, as well as all the way up. It's a victory for now. One of the things that we don't know is what the Biden administration may do with these rules. If they remain vacated by the court, they may just decide we're not going to enforce the rule anymore. We'll deal with it at a later basis. If Trump administration before Biden comes in succeeds in getting a higher court to overturn that and the rules go back into force, it's not quite sure exactly what Biden might do, in part because part of their campaign platform was to look at the wages of H-1B workers and some of the accusations that Americans are not being hired for these jobs, which these rules were meant to address. So there may be some sympathy from an incoming Biden administration to some of what these rules were attempting to do. But whether or not they would leave these specific rules in place, I think, is yet to be determined. And I think that's what the business community and the organizations that filed the requests for injunction against these rules are quite concerned about, that these regulations are attempting to implement changes that they believe are not, one, authorized under the statute. Now, as Sadiksha mentioned, the court ruled that they didn't follow proper procedure under the Administrative Procedure Act to make it an interim final rule. But another charge that was made that was not addressed by the court is whether or not these rules are permissible within the context of the statute itself. In other words, does the government have enough discretion to make these substantive changes, or is this what they call ultra vires, which is outside the rules? And I think that could definitely come back. There have been several attempts at changes to the H-1B program along these lines legislatively over the last several years, including some provisions in the recently passed Fairness for High Skilled Workers Act in the Senate. But we don't know exactly where this is going to come out. So there's a short time left before the end of the Trump administration. Courts don't necessarily rush their judgments based on electoral considerations like this, so they may not have enough time to appeal. But I'd say this is one to stay tuned on because we're not exactly sure which direction it's going to go.
All right. So with that in mind, let's turn to recent news regarding the DACA program. On December 4th, a judge of the U.S. District Court in Brooklyn ordered the Trump administration to fully restore an Obama-era initiative that protects undocumented immigrants brought to the U.S. as children from deportation, requiring officials to open the program to new applicants for the first time since 2017. So this is another significant ruling against the Trump administration in the last few weeks. Sadiksha, can you talk about the significance of the ruling and what it means for future DACA applicants?
Yeah, Rachel, I think you're right. This is quite significant that it passed, and the federal judge has ordered the government to fully reinstate DACA to its original 2012 program. Now, this means that an additional 300,000 undocumented immigrants who were not allowed to apply for protection from deportation can now go ahead and initially submit their application. The court ordered the administration to accept new application, and due to various legal battles, that had not been the case since 2017. So this is quite significant that after 3 years, a new flood of applications might open. The order is to take effect immediately, and anybody who is eligible can apply for the application process. Which is also quite significant about this is that in July 2020, Chad Wolf's memo, which had conceptually thought about reconsidering the DACA program, had implemented several different policy changes with the USCIS, and some of them were quite significant, such as it had taken down work permit from 2 years to 1 year. It had also put hold or rejected any initial applications for advanced parole, as well as initial applications or renewal. Now, this ruling vacates all of that. So instating it to the original form, it opens up application for many more undocumented candidates who were not previously able to apply.
So Theresa, looking ahead to 2021, how does this news bode for the incoming Biden administration, which has promised to introduce legislation in Congress that would provide DACA recipients a pathway to citizenship?
Yeah, I think there's two issues here. So the first is obviously what happens to the Trump administration's last attempts at ending DACA. And I think this is pretty much a nail in that coffin. The court said explicitly that Chad Wolf, based on a previous GAO analysis, is not currently serving lawfully as the acting Secretary of Department of Homeland Security. So his memo is unlawful. The Supreme Court decision in 2020 that said that the Trump administration did not end the program properly basically said they need to go back to the beginning, go back to how it was in 2012. The plaintiffs in this case sued because that's not what DHS and USCIS did, and they won pretty handily. So at this point in time, it is very unclear whether the Trump administration will be able to put in somebody in place in DHS and have them Senate confirmed to reissue all these regulations. So that might not happen. They have said that they will probably appeal, but just like with the last case, their time to file these appeals is running out. President-elect Biden has said he would introduce legislation in Congress. But the congressional process is long and involved and is uncertain. What is more likely, and probably in addition to that, is that he will basically stop the effort of the Trump administration to end the program. He will just continue it the way it was under the Obama administration. He may try to expand it or change it. The one outstanding question mark to all of this is that the state of Texas had sued the Obama administration back in the end of the President Obama's term over the DACA program. That case was held in abeyance while President Trump tried to end the program. And now that it looks like the program is continuing, that court case is now proceeding in the Southern District of Texas with the same judge who ordered that Obama's second program, DAPA, Deferred Action for Parents of DACA and Other Arrivals, was unlawful. So many advocates and many judicial watchers are quite concerned that that judge, Judge Hainan, would rule in this case that the DACA program itself was unlawful as created in 2012, and that might hamstring an incoming Biden administration being able to reinstitute the program with executive action. The hearing on that case is scheduled for right before Christmas, December 22nd. And if a decision is handed down shortly thereafter, that could definitely have an impact. So I would like to say that DACA and DACA recipients and dreamers can breathe a sigh of relief. But I think that that's not true. There is still jeopardy to this program. And we have said it before, we will say it again. The only long-lasting solution is if Congress can pass something. And I think the Biden administration will probably work as hard as it can to try to see something done early in its tenure on that.
The legal complexities truly do continue. Finally, we'll take a look at the recent ruling on the public charge rule. On December 2nd, the Ninth Circuit Court of Appeals upheld preliminary injunctions issued against DHS's public charge rule issued by the Northern District Court of California and the Eastern District Court of Washington. In its order, however, the panel majority vacated the Eastern District Court of Washington's entry of a nationwide injunction. So, Theresa, can you explain the ramifications of this complicated ruling? On what grounds did the court block the rule? What limitations are still in place? Give us a summary.
Yeah, so this is, as you struggle to explain it, you can see it's somewhat convoluted. We had two different courts issue injunctions against the public charge rule, but the injunctions were slightly different. One court had a nationwide injunction, and the other court's injunction only was valid in the district that they oversaw. So when the Ninth Circuit, which oversees both of these district courts, looked at it, what they said was they're going to keep the injunction for the areas within the Ninth Circuit, which is basically California, Washington State, Oregon, but that it can remain in place for the rest of the country. So it's a mixed bag, if you will, in terms of what it means. And again, the ruling was basically that the public charge rule as promulgated in its final form was overly broad. It was a significant departure from prior interpretations of this rule, that maybe it was not properly conceived. It was a lot of detailed sort of Administrative Procedure Act grounds, but essentially they said, this may be more than you have the authority to do. So it, again, like everything else in the Trump administration, will this be appealed? Certainly. They will try to appeal this to the Supreme Court. This public charge rule was the primary regulatory action, if you will, the number one priority regulatory action of the Trump administration throughout its tenure. It is the reason why the former USCIS director left, because he was not considered working hard enough to get this done. It was a priority of Stephen Miller. So we know that they don't want to let this one go, and they want it to stay in place. If it remains as a final rule, if the courts do not overturn it in full, incoming Biden administration would have to issue a new proposed rule to revoke it. It's a longer process, and maybe even try to write its own ruling on what public charge may or may not mean. But it would be difficult to not enforce the rule as it exists as a final rule if the courts don't overturn it. So As we all know, this has wide-reaching effects on anybody who is applying for a non-immigrant visa or an immigrant visa for the United States, in that it looks at every possible way in which you may have taken some form of public benefits or might take form of public benefits. It's a very complicated rule, and we already know that has impacted the number of cases adjudicated. So it's also a priority of a lot of advocates to try to see overturned. And I think, it's a good ruling, but we're not quite done yet.
So with that in mind, with all the changes that have occurred in the last few weeks, do you foresee the administration putting forth any new rules or regulations in the coming weeks, or just working with what they have?
Well, I think that there's probably an effort to do some final things. We have heard rumors. There was several proposed rules that have not yet been finalized, including a couple of on asylum. One other rule on the H-1B program that would revise its lottery system to prioritize applicants making higher wages and who have advanced degrees. I'm sure the administration is working hard to try to get those regulations put in final form before they leave office. With regard to the court cases, it's not all in the administration's hands. Obviously, they can file requests for appeal. It's up to the courts in their own time to decide when to hear them. They can choose to act on an emergency basis or not if they see good reason to do so. But my guess is that the Trump administration is running out of time to finalize all of these things. We may still see a few things coming out. I wouldn't rule out some late efforts to try to finalize some things, but we'll have to wait and see.
Well, that's a good place to leave it. So that's it for today's show. As our bi-weekly recording schedule would have us producing our next episode during the holiday break, we've decided to postpone our next episode until after the new year. So keep your eyes out for the newest episode that will be released the week of January 11th. Until then, we hope you have a safe and healthy end of 2020. I know I speak for many when I say we are excited to see what 2021 has in store. Before we go, a quick reminder to subscribe, rate, and review this podcast on Apple Podcasts, Google Play, Stitcher, Spotify, or your favorite podcast platform, and share it with your friends and colleagues. You can also find more information on all the issues we discussed here on the show today at bipartisanpolicy.org/immigration. You can follow us on Twitter at BPC_bipartisan. Theresa is on Twitter at BPC_TBrown. I'm Rachel Yakino. This Week in Immigration was created by Theresa Cardinal Brown. The executive producer of This Week in Immigration is Theresa Cardinal Brown. This week's episode was written by Theresa Cardinal Brown and myself, and Yafet Tawahada produces and edits our show. Join us again in 2021 on This Week in Immigration.